Transnational Law LLM pathway, and with his colleague, Prabha Kutaswaran, is the co-convener of the Summer Institute, as you've heard. And since opening its doors in September 2014, the Transnational Law Institute, which he guides so exemplary, has developed many programs. And I'd like to just give you some of its successes in numbers. I like numbers. From autumn 2014, when he arrived, to this summer, there have been 16 King's Forum on international dispute resolution events, 11 reading labs, 9 colloquia, 9 methods labs, 8 transnational regulatory governance research group events. I'm about to start singing this, you can see. No. 3 practitioners in the hot seat events, 3 national security law and research policy and initiative events, 2 transnational law summer institutes, and numerous conferences, roundtables, seminars, and more. There. Meanwhile, Bear continues to publish. There. He has many books, including Rough Consensus and Running Code, a theory of transnational private law, co-authored with Graf Peter Callis, with a foreword by Stuart Macaulay. Law in Transition, Human Rights, Rights, Development and Transnational Justice, Hart Publishing, co-edited with Ruth Buchanan. Beyond Territoriality, Transnational Legal Authority in an Age of Globalization, co-edited with Gunter Handel and Zoe Seko there. And there are many more publications available there. We owe you a great debt of gratitude for the energy with which you have started this wonderful initiative here at King's. The vote of thanks will be given by the man who brought you here, Professor David Caron, who convinced you to leave the snowy wilds of Canada for the equally freezing parts of London there. This evening's lecture will be followed by a reception back at the law school on the first floor, and there'll be people there to guide your way. Zumbansen, can I invite you to the podium to deliver your inaugural lecture, How, Where, and For Whom, Interrogating Laws, Forms, Locations, and Purposes. Hey.
Thank you so much, everyone, for coming and for this very wonderful exaggeration. In the 2002 film by British film director Stephen Frears, Dirty Pretty Things, we are taken into the gruesome precarity of illegal immigrants in London. Long before we find out where they are from or who they are and what they were doing in the countries they came from and were born in, we learn about their lives in London. Oakville drives a minicab and hustles fares at the airport during the day while operating the front desk at a hotel in nighttime. Sinead cleans rooms in that same hotel, and Juliette is a prostitute who brings her clients there. Together with Senor Juan, the shady and, as it turns out, organ trafficking hotel manager, and Wu Yi, Oakville's friend who works at a London hospital's mortuary, they make up the personnel of this deeply troubling movie, set in a Dickens London at the start of the 21st century, as Ted Hobbit called it. As Oakville says at some point, they are the people you do not see. Behind them, and even greater invisibility, however, are those for who the price of a false passport submit to the diligent removal of their kidneys in the hope of a new life in a new, allegedly better place. There is no shortness of poignant, unforgettable moments in the movie, but the final scene is special. Having obtained new passports, both Shinai, originally from Turkey, and the Nigerian Okwel, who used to work as a medical doctor in his country before fleeing from political persecution, are about to leave London. Shinai will go to New York to join her sister and yet realizes that she is leaving the man behind she has come to love. Okwel calls his once left behind daughter from the phone to tell her, "I am coming home." Home, thus, is the last word in the movie. It is perhaps the term towards which the movie was moving to from the start. It is at the same time, and as the actors made clear in every instant, the term that is among the most unstable ones in the story. Home once became and now continues to be deeply elusive for everyone. Home is pieced together by memories that with each passing day become more ephemeral, by attachments that are kept up and alive in their hearts and minds more than being lived out. Home is something that Shinai finds in thinking of and in longing to join her sister who already left Turkey, in her lover that never was, in a city and country that she feels will not be what she always dreamt it would be, however hard she tries to believe the romantic depictions of arriving one day in New York City. For Ogwin, home crystallizes in the voice of his daughter, the prospect of reconnecting with her in a country which he had to flee and now returns to. While the realization of home is fragile and volatile, and has been made so by factors that lie beyond the actor's reach or influence, the characters in Freer's film hold on to it. All this unfolds in what the film critic Ted Hobbit called the invisible London. He highlights the ways in which those who are invisible are so in multiple ways. They don't exist as citizens, taxpayers, social or healthcare benefits recipients. While from one point of view they occupy a universe which is off the grid of normal, legally regulated and administered urban life, we are drawn to take another perspective. A perspective from which we are prompted to see what we first could not see, and try to understand what we should understand even much better. Freers illustrates the parallel world inhabited by Ogwi, Shinai and the others by placing their movements in a labyrinth of backway alleys, back entries and fire escapes. A world where the minicab company is under a roaring train bridge and occupies a hole in a wall in which fleeting human interactions take place. A world where the already somber mortuary is hidden in the deep down belly of a seemingly gargantuan hospital and yet provides occasional nighttime shelter that Wu Yi offers to those who need a place to spend the night. A world where the keys to an illegally shared apartment between day and night workers are swapped at the fruit stand of a convenience store. What might we possibly draw from these observations? Can they help to illuminate more than what we can see at first glance? But what are we looking at, in fact? Does the movie really tell us very much about illegal migrants and migrant workers? Does it help us even a little in understanding the ins and outs, origins and drivers, as well as the implications of illegal immigration, but also of organ trafficking and the sophisticated transnational economy that sustains it? What then are we prompted, if not to understand, then to at least be wondering about and investigating? The conditions of migrant workers everywhere, the plight of people on the move, the desperate attempts of crossing lands and waters to a better life, and the daily, hourly, miniature experience of a life in illegality in the shadows, in the doldrums. Struggles that a Northern European Minister of Integration, perhaps out of good intent but embarrassingly and terribly poorly, tried to emulate and, as she said, to experience in her own body when she allowed herself to be tossed into the sea just a few days ago. Wearing, however, an expensive survival suit, and with camera teams and rescue personnel floating in closest proximity. What then do we want to know about this poignant subset of the Precariat, as Guy Standing has called it, a worldwide constituency of those placed at risk, those without realistic hope of ever coming to the top again, or reaching any top ever, any more or less safe haven for themselves or their family, a momentary resting place or refuge, for that matter. About those who seem to become eternally excluded, wronged by the contingencies of birthplace and time, by deprivation of political, social and economic rights. About those who for a moment in 2011 and 2012 were believing in a reversal of exploitation and domination and the arrival of spring, only to find themselves today in an even more precarious condition of consolidation of the old and abusive structures. About those, then, who irreversibly have fallen victim to the so-called flexibilization of labor markets that have been accompanying in lockstep the legally initiated and legally orchestrated liberalization of markets, capital flows, and investment streams. and those who have been working the ropes of a globe-encompassing service and construction industry as part of the Philippines' large-scale export of child carers, housemaids and nurses into well-off Western households, or of garment workers in sweatshops in Bangladesh, Vietnam and Indonesia, and of construction workers in Qatar, the Emirates, but also in London, Berlin and elsewhere. About those who have been set adrift in the 1980s under the mantra of no alternative, and then were prompted to fight on their own or to be blamed for personal all-consuming failure. About those, then, who under the auspices of austerity are now being placed in a waiting room for a return of collective action, democratic self-governance, and redistributive politics, which, as they all know, will never come. About those, then, about who after having been told they ought to consume until they can consume no more, find themselves buried by debt, unpaid mortgages, credit cards, and student loans. The hustle that continues unabatedly for everyone who was already badly off before the 2008 financial crisis and finds herself in even more desperate conditions today is the old and new normal of the 99%. This is a precariat that is ubiquitous, transnational but not borderless. Borders matter greatly. They draw lines around the space I may effectively traverse and occupy. In few instances does the correlation between economic and legal space become so tangible as here. Markets and their attending logic and needs have come to decenter, if not displace, the state, as the left in the West would depict the trajectory of 1970s inflation, the rise of public debt in the 1980s, and that of private as well as corporate and financial sector debt since the mid-90s. The state in this picture is the operator within the post-World War II context of embedded liberalism, but increasingly perceived also as the nodal point of economic forces that it could no longer contain or even less control. The financialization of the economy mirrored that of a private business company. Had it made sense at some point still to speak about the public responsibility of a corporation under the leadership of one or the other socially committed CEO, we have come to think differently about agency today. Neither the state nor a CEO, neither the Greek population nor the occupants of public spaces in Cairo, Istanbul, or Barcelona are credited or believed to have agency in the face of so-called economic constraints. This loss of political agency stands in disconcerting contrast to the strange and legally highly ambiguous rise of a series of humanitarian interventions that has provoked mixed reactions, with some condemning such action as new imperialism and others recognizing the fragmentary beginnings of global justice politics. Under the tractor beam, not of the Death Star, but of emergency imaginary, as Greg Calhoun called it, overwhelmingly complex conditions in our world today become the targets, chosen, we should emphasize, by those with the means of choosing and developing them, of complexity-reducing responses that are morally pure and immediately good, Calhoun writes. This skewing of options in a debate, the settling on what is required and necessary, and ultimately being sold as inevitable and effective, is possible because the spaces of effective political intervention have become smaller. That is, of course, paradoxical, that the spaces of exchanging information, opinions, and protest seem to have grown exponentially through the internet. That the immediacy and proximity of someone else's suffering, which we can and are following in real time on our phone screens, does not translate into directly assumable political action. Dave Eggers' most recent literary creation, the hot desk worker in a Google-like internet company who digitally signs dozens of political petitions for diverse political causes around the world in a manner of seconds, is among the best caricatures of our present-day hopes for e-government and a digital public. Painted against the background of an, as is being said, ubiquitous and constant threat of terror, the emerging picture is fuzzy at best, both at the center and in its contours. as the institutional structures that we expect to provide guidance with regard to who has and who can effectively assume political responsibility and agency today have become ever more volatile, we are experiencing another loss. It is the loss of language. The loss of being able to adequately depict and capture the complexity of the developments which engulf us. For many in the West, this loss of language is only the outer layer of a feeling of loss that reaches much deeper. This feeling is being experienced on the basis of still recent memories of a progressive development of state protection, of a development from negative rights to positive ones, empowering and sustaining rights, and of a universe where one could choose between left and right political options against the backdrop that an acceptable flaw of the underlying institutional infrastructure would continue to exist. So, when in the West the dramatic impact of globalization on the economic, political, as well as legal conditions of our way of life is being lamented, not all of this is pure self-indulgence. It is, at least in part, also an appreciation and a historically minded endorsement of political choices that once facilitated a comprehensive system of welfare institutions. That many of these choices could only have become choices as a result of affluence, favorable trading conditions, and low unemployment and inflation in the 1950s and early 60s is a fact that not only needs to be remembered in its own right, but it also needs to be placed in a global context. It is important for a localized political discourse that aims at reconstructing and indeed cherishing the steps taken towards the present precarious state of either resignation or radicalization, and a situation of shrinking political choices, to carefully trace back the progressive development of a welfare state system which looks after its own. But such self-reassurance and self-inspection is not enough if it is walled off from the world around it, which in large part has made many of these Western achievements possible in the first place. It is to the gap between our localized and complex processes of historical accounting and competing views of the story that we ought to now turn our attention. There are several ways to do that, and we can perhaps only point to a small number of them in the time here available. While we will, in turn, consider the growing distance between what Nancy Fraser has called normal and abnormal justice, on the one hand, and engage with the contentions made by scholars associated with post-colonial studies and TWAIL, the third world approaches to international law, school of thought on the other, we may nevertheless first try to draw attention to what seems to be the bigger picture here today. This picture we could see as being comprised of an increasingly influential critical engagement with competing knowledges and indicators. It is a critical stance taken towards deeply entrenched conflicts between dominated as well as suppressed epistemologies, between discourse determining paradigms as well as those that are being silenced and marginalized. Students of literary criticism, sociology and anthropology, post-colonialism, critical race theory, and geography have for some time now become accustomed to this critique. Meanwhile, lawyers have started to wake up, perhaps late and only quite slowly, to this rich interdisciplinary critique of violent languages, which expresses itself today in ever more slick formulas with massive behavior conditioning, impact, and effect. Dolly, you should have some of the water. Lawyer and anthropologist Eve Darren Smith, who spent a precious 10 days with many of us last June and July at the Inaugural Transnational Law Summer Institute, asked in an important new essay the following: who produces knowledge about whom? What form does this knowledge take? How is this knowledge amassed and disseminated? And perhaps most importantly, what instrumental action does this knowledge enable? Building on a careful engagement with non-European humanities scholarship and her own ethnographic fieldwork, as well as decades of social, legal, and anthropological research, she went on to observe that the current quantitative turn in data collection and policy development, quote, reveals a particular European modernist worldview that values scientific and empirical knowledge and gives authority to essentializing, compartmentalizing, and measuring particular aspects of people's lives and translating these experiences into universally applicable indicators. This critique of indicators, which the anthropologist and long friend of King's and the law school, Professor Sally Mary, labeled political technology, is an important battleground and site of engagement of contemporary global governance practices. Indicators technologies are at the heart of an ambitious and polycentric framework of public and private, domestic and international regulatory architectures that operate with very asymmetric dynamics between the north and the south. And yet, given that they purportedly only collect and measure facts as data, indicators are being presented by its promoters, such as the World Bank, as mere containers of information, on the basis of which, however, problem solutions can be tailored and rolled out. Meanwhile, the critique of indicators that has been developed by scholars such as Sally Mary in collaboration with Kingsbury and Kevin Davis at NYU, or by Carrie Rittick in Toronto, Amanda Perry-Casares at Kent, David Nelken here at King's, or René Orenia at Los Andes in Bogota, or Fleur Johns at UNSW in Sydney, has crucially developed to lay bare their problematic epistemological bias as well as the indicator's instrumental malleability. As they come to constitute a metabolizing part of the DNA of the transnational rule of law, indicators have started to influence our perspectives on the world and its problems as well as possible solutions. Ironically, and indeed problematically, indicators, as they become ever more fine-tuned and detail-oriented, reinforce the turn to expertise which scholars such as Upendra Bakshi, Boa Santos, and David Kennedy have long identified as a crucial challenge to forms of collective political deliberation. Who would not want to trust an expert rather than a conniving, ultimately self-interested politician, you might ask? What we see developing here, however, is something which is hardly exclusive or limited to the skeptically regarded transnational private regulatory governance. That is, the consecutive displacement of state-run policymaking by private standard setting and non-legal norm production. The expert and expertise-driven transformation of the nation-state's actors, norms, and processes started in the laboratories of both liberal as well as authoritarian, northern as well as southern administrative states. It began first on the inside in developing sophisticated infrastructure and society management frameworks, and was then transported first into colonies and post-colonies before being uploaded into global institutions such as the Bretton Woods organizations or others such as the World Health Organization or the Codex Alimentarius Commission. Administrative bodies stacked by experts with their ear close to the ground and their short connections to state finance and private money have always been the real engine of the nation-state, as well as increasingly of different global governance actors. Meanwhile, in the absence of a world stage, parliamentary or constitutional infrastructure, the legitimation of global governance actors is almost desperately being sought elsewhere, either on the level of the contributing nation-state or through the development of principles of accountability and transparency in the form of a very Western so-called administrative law. When you continue now to turn your attention to those writing in and from the perspective of the global South, take for example the brilliant Egyptian legal academic Usha Natarajan at the American University in Cairo, or the Colombian social legal scholar and activist Cesar Rodriguez Garavito at the University of Los Andes in Bogota, you find daring explicit suspicions regarding a dominant technocentrist bias dramatically confirmed. In Natarajan's work, we find an insightful critique of how Western modernist concepts of progress and economic growth created century-long external and internal domination trajectories which cast their shadows well over the courageous struggles that manifested themselves before the world's eyes on and around Tahrir Square only a few years ago. Rodriguez Garavito, in turn, calling for a distinct turning away of Latin American law and society scholarship from parroting US, American, and Western European categories and frameworks, has argued in its 2015 edited collection that most of the existing law and society depictions coming from the North and West simply get the facts wrong of how laws and societies are actually correlated in Latin America today. Rather than allowing Latin America to continue to be the reception context for the import of Western norms and theories and doctrines from the production context of the global North, Latin American scholars ought to resist being continuously exoticized and instead engage in a process of counter-mapping, that is to represent a territory he writes from perspectives that are different from the dominant. The transnationalization not only of economic and human connections and interactions is complemented by a transnationalization of regulatory infrastructures and institutions. It is against this background that we should not stop and even begin to take credit for having dared to take a look across the state's confines to gain, if only a glimpse of the world that surrounds it. Rather, we begin to realize that our gaze has now become restless, our points of orientation and reference questionable. An important insight from this scholarship, then, is the realization that not all is really well at home either. Complementing the turn against Western-dominated frameworks and concepts to measure societal progress, etc., is an ever more mature analysis of the correlations between colonial, post-colonial rule and Western global governance developments. As Latin American scholars remind us to take a closer look at what actually has been emerging in terms of economic and social policy in the last 2 decades, and how these have been shaped by international economic policies, they also provide fresh insight into the failures that have been marking the West's attempts at governing the world, to use a phrase by Mark Mazzaro. They prompt us indeed to consider more honestly the realities of political discourse and participation, the achievements of exclusion and the dark blotches of denial of entry and what the French call refoulement, as these have been in turn impacting political life and citizens in the West and the North. Taking the suggestion to heart, we turn our eyes again onto ourselves in search of a better understanding of current allocations and distributions of both political and economic power. In that effort, we are looking for a better understanding of the correlations of the malaise of the post-financial crisis in the West and the asymmetrically occurring developments elsewhere and all around us, if we cared or dared to still take this view of us versus them. What we see is anything but comforting or encouraging. Today, the juxtaposition of what Nancy Fraser so insightfully has called normal and abnormal justice has become disturbingly obvious and tangible. So long, Fraser writes in 2008 in an essay dedicated to the late Richard Rorty, as deviations remain private or appear as anomalies, so long as they do not accumulate and destructure the discourse, the field of public sphere conflicts over justice retains a recognizable, hence a normal shape. She continues, and please allow me to quote her in some length, "By this standard, the present context is one of abnormal justice. Even as public debates about justice proliferate, they increasingly lack the structured character of normal discourse. Today's disputants often lack any shared understanding of what the authors of justice claims should look like, as some countenance groups and communities, while others admit only individuals. Likewise, those who argue about justice today often share no view of the agency of redress, as some envision new transnational or cosmopolitan institutions, while others restrict their appeals to territorial states. Often, too, the disputants hold divergent views of the proper circle of interlocutors, as some address their claims to international public opinion, while others would confine discussion within bounded polities. In addition, present-day contestants often disagree about who is entitled to consideration in matters of justice, as some accord standing to all human beings, while others restrict concern to their fellow citizens. Then, too, they frequently disagree about the conceptual space within which claims for justice can arise, as some admit only economic claims for distribution, while others would admit cultural claims for recognition and political claims for representation. Finally, today's disputants often disagree as to which social cleavages can harbor injustices, as some admit only nationality and class, while others accept gender and sexuality. As if to further extenuate this description, Ivar Ong wrote in 2005 that, I quote, "In an ever-shifting landscape configured by mobilities and positionalities, the idea of citizenship tied to the terrain and imagination of a nation-state is called into question. As rights and protections long associated with citizenship are becoming disarticulated from the state, they are re-articulated with elements such as market-based interests, transnational agencies, mobile elites, and marginalized populations. Such a contention must indeed clash with the sense of a frightening naturalness, even inevitability of present-day economic conditions, marked by immense public and private debt as well as minimal growth, and heightened strangely, undyingly, as Colin Crouch has remarked, by a rhetoric that worldwide markets require the current political responses, altogether tailored towards the rebuilding of confidence in just these markets. But leaving so much of what we have drawn attention to out of the picture and instead to short-circuit the search for a sustainable legal political framework with the personalized, allegedly unquestionable demands of the market can hardly convince at this point. Too strongly do the references to the need of taking a broader view resonate in fact. What remains to do at this point is perhaps merely to indicate the outlines of what lies before us, as lawyers, if you allow me the introspective turn at this moment. I would thus like to argue for a perspective on the place of law in this discussion, and equally a perspective on the place and role of lawyers, and of the frameworks through which they are educated, trained, and professionalized. So then I ask for a little more of your patience in putting forward and testing with a few hypotheses. These include, first, law can and must be seen as semi-fluid, historically and geographically evolving as a composite of the following characteristics. Law as a body of doctrine for the use of problem solving. Then law as an institutional framework for the accommodation of decision-making processes and establishing as well as evolving routines of conflict resolution. And law as a repository of largely symbolic, if not ephemeral, associations of the term with ideas of justice or equity on the one hand, but also violence, repression, and exploitation on the other. Taken together, this combination of institutional and normative associations with law does not exist in a heaven of pure conceptual truth. In order to adequately address law as comprising these dimensions, it is necessary to seek out the manifold, local, competing manifestations of law in its different forms, in its concrete contexts, here and there, now and then. Second, the study of law with an emphasis on its existence and operation in concrete processes on the ground implies a double strategy of both re-embedding and disembedding law. While we need to descend from the heaven of pure legal concepts into the often messy and inchoate realm of the living law, as Ehrlich called it, and as my colleagues are trying to illustrate to their students in the new LLM program in Transnational Law here at King's, we also need to free ourselves from seeing what we came to see through the lens we have gotten used to wear. In other words, we need to actively recognize the tension between the theory and the practice of law, but simultaneously must do so in light of crucial historical and global contingencies, which leads to a multiplication of such stories about abstract principles and concrete manifestations. It was one of the insights of legal sociologists that deconstructing legal positivism's purported stronghold over lived experiences of the law could only be the first step. The second one had to be the open-minded, impartial, and tireless engagement with other experiences, alternative narratives, and competing accounts of rise and fall, progress or decline. Today, building on these insights, the intertwined projects of comparative law and legal pluralism need to be revived, but not merely as elective options and luxury leisure fields to satisfy intellectual curiosity of students in upper year programs, but as essential sets of toolkits in core legal work and first year legal analysis. To state the thesis even more plainly, there is no clear line running between a pure coherent body of law and a pluralist, incoherent and informal mass of non-law. The construction of such a line is often the result of having asked the wrong question. Thesis 3 then regards a different question. Rather than being concerned with the definition of law from the perspective of what is X, we should be trying to understand the situation in which the alleged distinctions between law and non-law are being invoked. This involves a decentering and again postponing of questions that regard competing definitions in the form of law is X or Y in favor of questions that aim at uncovering the interests and stakes that are involved and taught up in the invocation and use of and the aspiration for law. Why did, at a certain point in time and place, lawyers and judges hold the opinion that a woman who kills her sleeping husband is a murderer rather than acting in self-defense? What in fact is required so that the so-called Bangladesh Accord that was signed by numerous multinational garment importing business corporations in the aftermath of the tragic early 2013 collapse of the 8-story tall Rana Plaza building in Dhaka, at which more than 1,100 workers died, can be seen as a legal instrument giving rise to enforceability and liability claims. What is at stake here is that what is and is not law is not given nor universally true or false, but results from human interaction and struggle. From this follows our fourth thesis, namely that in order to understand what law is, we need to appreciate the different aspects that shape the disputes over law. These disputes arise in multiple spaces, which makes their investigation so challenging and requires us to take a transnational knowledge transfer in numerous directions seriously. How, in fact, does one ever get a clear picture of the obvious as well as the latent, hidden, excluded conflicts and disputes in a concrete and complex situation? Yet, can a lawyer really speak about a case without having the bigger picture of what the case is really about, including those directly involved in it as parties, as well as those who stand to benefit or incur losses and degradation from a certain outcome of that very case, as either proximate or more distant stakeholders, as bystanders or as members of a larger affected community? Who draws the line between those being affected and those who allegedly are not? Yes, questions of agency complement questions of substance, but they cannot replace them. This leads us finally to our last thesis, thesis 5. Despite the seemingly overwhelming sociological and anthropological evidence which pushes the bigger questions over definition, nature and quality of law to the bottom of the pile in order to focus on the nitty-gritty of actual norms, their creation and operation, we want to contend that questions of justice remain a crucial element in any interrogation of law in a global context. That is true also despite the untiring and so very important critical contestation of supposedly universally accepted or shared values. Before I want to take you back to a brief reflection, very brief, on the theme we began with, namely home, spaces of being and belonging, let me briefly suggest how our observations so far, including the just presented thesis, might be operationalized. I want to do that by drawing your attention to the idea of a legal field. Returning to Stephen Frears' movie and its protagonists, a lawyer might see there an artistic engagement with a relatively small number of legal fields. Among those, she might identify refugee and asylum law, labor and employment law, as well as criminal law. Stepping back from the film then, the lawyer would ask herself whether and how she could be trained to be competently offering legal advice on all these different fronts. She would, in other words, be confronted with a real-world illustration of a case that looks easy at the outset but has many different intriguing aspects to it. But we might ask, is that really all? Do these fields, all of these fields, capture the law that governs the situation and all of the law that captures the situation? What, in other words, is the situation that the film drew our attention to? Is it confined to the facts that are made legally relevant through the lenses of refugee or asylum law, labor, employment, or criminal law? Or is there something else that constitutes the legal framework of the situation, say as an outer layer? We currently hear from promoters of Brexit that a no to the EU would solve the immigration and refugee problem in the UK. That, notwithstanding the relatively simple assertion that Calais would still be there after Brexit, and with it the interest among refugees and migrants to come onto the island. There's a particular similarity, I think, between this reference to the actually factually existing port of Calais and the alluded to outer layers of the case of the London illegal immigrants. This similarity illustrates itself in there being a bigger picture to both. The refugee, asylum seeker, the migrant, legal, illegal, legalized or rejected, does not exist in a vacuum, but in a situation that is part of a bigger transnational one. This situation requires a more sophisticated and sustained analysis of origins and drivers, forces and causes that, after many diversions, manifest themselves in a particular individual's or group's concrete possibilities to maneuver in Calais, London, or elsewhere. In other words, whether we want to apply a body of norms to administer and ultimately remove a file on our desk, or whether we want to follow and allow ourselves to take a step back to begin to appreciate that there is a case behind the case, and behind that case, another case, is a question of choice. It is a deeply political one, and as such, not one which you can render inexistent by saying it is not the case that is in the hands of the lawyer or before the judge. You can only choose to render the larger case behind the case invisible for different reasons, but you cannot actually make it go away. Any social legal scholar will tell you that this is no more than the ABC or 101 of explaining the correlation between and the co-constituted nature of law and society on the first day of class. And yet, so my contention, we do draw attention to the case behind and beneath the case only too rarely. We don't need to, it seems, as students over the course of their training will have had plenty of opportunities to connect the dots and to recognize the need of seeing the different, highly specialized and compartmentalized fields of law and their respective terminologies and principles in, indeed, a larger context. They will, so we must hope, somehow and at some point appreciate how each legal field is merely a tool to reduce a set of complex facts into a manageable mass of legally relevant data. They will then, so we hope, increasingly, however, against better judgment, learn how to do the case-specific, technically complex and detail-rich lawyerly work on the one hand, while being able to always see the connections between these distinct legal operations and also between those and the larger socio-economic geopolitical changes that provide the context in which it all happens on the other. Well, we learn from William Twining that making students find the many, many first hidden manifestations of law, norms, and the legal system in any given newspaper is only the first day's order. And that in order to make students appreciate the productive tension between legal and normative pluralism, it requires a constant and recurring confronting of the students' growing confidence that they have got it right with how possibly wrong they might be in fact. It requires, and now we turn from Twining students to us, lawyers as a group, it requires us to be skeptical about our confidence in the use of our terminology, our principles and values, but also in our self-assured ways of drawing lines between fields of law as between law and other disciplines. In short, it requires us to keep our eyes and ears open but also our minds, to all that we are bound to miss in continuing to approach the world in our learned ways. How is this, then, connected to the still lively discussed notion of there being a transnational law? How do different legal scholars and practitioners, but also members of other disciplines, understand, define, or approach transnational law? I have tried to sketch tonight a few of the concurring developments inside and outside of law, which shape our understanding of how far we can rely on law as a tool to solve problems. I have tried to show some of the challenges that arise for law being understood as a product, but also a proud achievement of a nation-state committed to democracy and the rule of law, in a world where the state's regulatory and normative sovereignty has become eroded from below and from above, as Saskia Sassen so astutely described it. A world, furthermore, in which the rule of law has been transforming into malleable shapes and processes of infinite operationality, provides a context in which neither the state nor the rule of law can simply be assumed to be home to law and all of the aspirations we associate with it. As Arjun Appadurai in his remarkable 1996 book, Modernity at Large, observed with regard to the nation-state, having been set at large by globalization, we can say that law risks being set adrift and at large if we cannot find ways of rethinking and reimagining it. The work of post-colonial scholars such as Akhil Memli or Dipesh Chakrabarti, but also others, including Azad Saeed, whose work on Orientalism our students read this semester, is a crucial and absolutely essential contribution to such a project of decentering and reversing perspectives. The important scholarship that has been produced by trail scholars in the last 20 years will have to be reckoned with much more seriously by mainstream public international lawyers who continue to risk being caught between fragmentation anxieties and normative hyperbole. Transnational law, well, transnational law, emerges as a methodological and discursive space to test competing theories of law in their relationship to the discipline's own history and its forward-going trajectory. It is a site of engagement between law and its differentiation into various specialized and applied fields with non-legal disciplines, which are likewise, even existentially so, interested in the problems that lawyers should be struggling with today. Transnational law is a methodological perspective on law's contentions of being tied to particular institutions and processes whose existence is too often being taken for granted, rather than as an opportunity to reflect on the historical origins and the forces that have been shaping their journey. Transnational law, then, is law in today's world context. It asks whether we are ultimately right in thinking that only Okwi, Juliet, and Chennai are the migratory ones, the ones set adrift and without refuge. Let me leave you with a few lines from the writer and journalist Frances Stoner Saunders from her remarkable essay in the London Review of Books, published in March earlier this year. Reflecting on the 2013 disaster in the Adriatic Sea off Lampedusa, during which more than 360 refugees drowned, she wrote the following: I have no theory, no grand narrative to explain why so many people are clambering into their own hearses before they are actually dead. I don't understand the mechanisms by which globalization, with all its hype of mobility and the collapse of distance and terrain, has instead delivered a world of barricades and partition, in which entire populations seem to be living and dying in a different history from mine. All I know is that a woman who believed in the future drowned while giving birth, and we have no idea who she was. And it's this, her lack of known identity, which places us, who are fed with it, in direct, if hopelessly unequal relationship to her.
Tonight has been a very special night. We treasure our professors. We, as societies, invest so much in evaluating our young academics, cultivating them in hopes that we get a great professor. For the professor, I think as Evelyn Welsh said tonight, the inaugural lecture is our celebration of finding such a professor. At the same time, I would tell you, for the professor, it can be an intimidating moment. It's a public moment in which you show everything about yourself. Per, tonight you have raised that level of intimidation for a lot of people. Per's lecture will be dissected, debated, and cited for as long as these circumstances remain, and that is a very long time. Congratulations on a very wonderful lecture.